The Supreme Court of Appeal has reserved judgment in the Jacob Zuma matter. Zuma's lawyers argued that Arthur Fraser acted lawfully when he granted medical parole to the former president. Correctional Services also submitted it couldn't be correct that recommendations from the Parole Advisory Board were binding. Zuma's advocate Dalim Mpofu says sending Zuma back to jail would be like a double sentence considering the amount of time he served already. Let's speak to legal analyst Benedict Phiri on this particular matter. Mr. Phiri, good morning and thank you very much for your time. Perhaps let's start where the court started yesterday. The powers of then Commissioner Arthur Fraser. It seems that his powers can be located in Section 75, subsection 7A. We all know that clearly, according to that section, he could actually be somebody that grants parole if it's within the 24 months, but it became the process followed at arriving at the decision to grant that seemed to be the most contentious part. Talk to us about the arguments by Advocate Mphahlele there. What did you make of them?
Yeah, and I think that's a good place to start, because when you look at Section 75(7), it does appear to confer a general discretion on the Commissioner on the granting of medical parole. But I think where the court and all the legal counsel quickly were aligned on is that actually Section 79 is also very important in the sense that it becomes then the framework for the granting of medical parole. And once you do that, then you actually test the commissioner's decision, because it isn't just a general discretion that's just subject to the strictures of legality and rationality. It then also is subject to the further requirements in the regulations around then there must be a terminal illness for the prisoner, or it must be a physical incapacity that limits their daily functions essentially. And that then became a stumbling block for both the Commissioner and Zuma, because they could not show a terminal illness quite comprehensively at all. And that became an opening to show that then the Commissioner's decision was really under attack, because even if you could say he had the power under Section 75(7), he still needed to show either a terminal illness or physical incapacitation, which wasn't shown in this particular instance.
And they spent quite a lot of time discussing. Yes, they spent quite a lot of time, the judges there, just seeking clarity around the terminal illness aspect, which now needed to be actually satisfied in Section 79. Now, with 79, the amendments became the problem, because most of the legal counsel stated that, yes, it was satisfied that indeed there is a terminal illness, but was it at an advanced stage, which now was included as an amendment to Section 79. So that seemed to be really quite a part that they struggled to prove. Did you believe there was greater struggle there?
Yes, I certainly believe that, because, you know, Mr. Zuma and the Correctional Services Department pinned their argument on a report by Dr. Mafe, which was really the application for medical parole. They forgot every other report that was obtained by the Medical Parole Advisory Board, which said something completely different. And over and above that, even the answer to the question by Dr. Mafe wasn't quite clear around whether there was a terminal illness or a chronic condition. Right? So that wasn't clear and in of itself within the application. So then the question becomes, well, the initial recommendation or the application from Dr. Mafe isn't very clear in and of its own around a terminal illness. And over and above that, the Medical Parole Advisory Board basically says there is no terminal illness. So on what basis then, given the amendments to the Act, can either the Medical Parole Advisory Board recommend parole, medical parole, or the Commissioner? And so from my perspective, that was quite a difficult task, and they didn't really succeed in that respect.
The other aspect that I'm not sure how they fared on was the reducted part of that medical report. I remember Justice Plaskett actually spent a bit of time there saying, you know what, they felt it would be difficult to make a determination around the rationality or lawfulness of that decision if that critical part around the terminal illness was removed or reducted from the medical report. But Advocate Mphahlele's response was that the High Court felt they could still make a ruling, so they feel there's nothing there. What did you make of that?
That was an important part of the matter, because that then goes not only to the lawfulness of the commissioner's conduct in this particular instance, but also what would be an appropriate remedy in the circumstances. Because yes, if we cannot test, or the court cannot test, the reasons that Arthur Fraser gave in respect of making the decision, and actually test what information he had at his disposal, and it looks prima facie that he made the wrong decision, because from what he said in his reasons, he didn't seem to have regard to any terminal illness. He had regard to other factors. So even with the redaction, it's hard to say if he actually did have regard to factors that pointed to a terminal illness. And therefore, that then goes to showing more an unlawfulness than a lawfulness in the decision-making. But why it's also important is one of the things the court has to consider is whether they send this decision back to the commissioner if they declare that conduct unlawful, or the court actually substitutes the decision of the commissioner with its own decision. Now, part of the assessment in deciding whether the decision should go back to the commissioner will go to actually whether the commissioner had the right information, and whether the court has the right information to be able to be in his shoes and exercise that decision. So that will be an important consideration for the court in determining what actually happens if it declares the conduct of the commissioner unlawful in this particular instance.
No, that is a very interesting and important aspect of that case. But then, don't you think, from the outside looking in, an ordinary person could say, though, that perhaps the Correctional Services Department shot themselves in the foot at the very least, if they're still standing by their decision that it was lawful, and the records, the medical records, informed that decision. But one would say they probably shot themselves in the foot by not submitting the unredacted medical record in the lower court. And if that is the case, how easy or difficult would it be to submit such documents that were not admitted back then in the lower court at this phase of this case, or at this stage of the case?
Yeah, and it's a bit of a travesty that those records were not, complete or 100%, because not only is the court hamstrung in the sense that it can't actually make a proper determination of what actually stood before the commissioner. So the court's review powers are not being given full effect to in this particular instance. But certainly from the outside looking in, as you say, it's opaque. And there's a question mark around why there isn't transparency with respect to this process, particularly given, what's at stake. So I think, from a reputational perspective as well, the Correctional Services Department has shot itself in the foot in this respect. I don't think it assisted any of the parties, and may have actually played into the hands of the DA, AfriForum, and the Helen Suzman Foundation. Unfortunately, at this stage of the proceedings, that record cannot be introduced in an unredacted form, because what the Supreme Court of Appeal has to decide is whether Judge Matojane effectively made the right decision based on the case that was presented to him in the North Gauteng High Court in Pretoria.
All right, Benedict, thank you very much for your insights. That was legal analyst Benedict Phiri.